Personal property is our next topic, and I ask, what is property? I think we can all kind of provide an example of what's property, but can we really define it? Generally, I guess it entails items that are capable of being owned, right? That's a general kind of definition. But of course, the law does a nice, unclear definition of it, but we'll break this one down. And under the law, property consists of the legally protected rights and interests a person has in anything with an ascertainable value that is subject to ownership. And as we move through this topic of personal property, we'll kind of define what all that really means. And as we talked about in earlier topics with regards to ownership, refers to who has title. So the major function of the legal system is going to be providing us with laws that define the right to use property, to sell property, to dispose of property, and to prevent trespass on the property. Like I said, ownership of property refers to, as the title, whoever's holding it, a person who holds these rights to the property, i.e. using them, possess them, dispose of them, keep people from taking them or excluding people. That's actually said to be, you'd be said to be the owner in fee simple. Another fun legal term. We also use that term in real property. But you have ownership, i.e. title, and because you have ownership, you have these rights to use the property any way you want, possess it any way you want, dispose of it any way you want, exclude others any way you want. And those bundle of rights is something we call fee simple. And what that ultimately means is that upon your death, your property will move on or pass to whoever you leave that property to or your heirs. And we have classifications of property. We'll talk about real property versus personal property, tangible property versus intangible property, public property versus private property. Actually, let's do that one first. There's not a whole lot of discussion on public property and private property. What's the difference? Public property is owned by the government. Private property is owned by individuals. Tangible versus intangible. We'll talk more about it. Tangible is you can physically possess it. Intangible, it exists in some other fashion that you can't tangibly touch. Real property versus personal property. Real property is land. And personal property is everything else. So when people share ownership, meaning that they have rights simultaneously in a particular property, they're said to be concurrent owners, but we have two types of concurrent ownership. We have tenancy in common and joint tenancy. The tenancy in common, each owners own undivided fractional interest in property. And with a joint tenancy, we have co-ownership of property in which each party owns an undivided portion of the property. So I'm going to kind of explain the difference between the two. Tenants in common, you own, and we talked about this when we talked about fungible goods. Remember the grain, holding the grain in a silo, 3 different people own it. They own a third, 3 people own it. They own undivided fractional interest, 1/3, 1/3, 1/3. And if somebody in that third dies or sells it, it goes to heirs or another person. With a joint tenancy, you're owning undivided portion of property, so you kind of own it all together. And if somebody in that group passes, the right dies, when I say passes, their rights go to the other folks who own the tenancy and the property. So the difference is how that passes upon, how the property interest passes upon one's death. The common one is tenancy in common. If you acquire property, 2 or more people, and you don't specify that it's a joint tenancy, it's automatically a tenants in common. And joint tenancy is usually how husband and wife own property. One passes, the other gets it. You may have heard a term, right of survivorship. That term only applies to married couples, and what that means is if, let's say, the husband passes away and he has particular debts, that those creditors cannot come and take the land from the widow. And that is a kind of very old law. Back in the day, women couldn't obtain credit without their husband's consent. So, and they also wanted to protect a woman's interest in the home, had husbands gone out and created debt and then passed before the wife did. They didn't want to allow creditors to come and take that property and create her to be destitute. But we won't be talking about right of survivorship. Actually, we will talk about right of survivorship more when we're talking about real property. But for purposes of personal property, we have these 2 ways in which people share ownership. So nature of personal property. Back to real property, because I need to use real property to distinguish from personal property. With real property, that we'll talk about the next time, is land and things attached to land permanently. We talked about fixtures and we talked about mortgages, trees, plants, things that are non-movable. Land is considered real property. So land and the things that are attached to land permanently, that's real property. So I ask you, what if you cut the trees down or you grow crops? Well, if you're going to sever or extract, maybe it's minerals from land. If you remember back from our sale of goods, those things become goods, i.e. then personal property. So those cut singly out or moved from the land, trees, minerals, crops, those things are going to become personal property. Has to be attached to the land permanently. And I just added that question of what law governs. If we're talking about real estate, land things attached and permanently to it, fixtures and such, that's the common law if there's any problems that arise. And if we are removing these trees or minerals or crops, they're considered goods. So Article 2, if there's any contract problem that comes up. So then I defined personal property. And personal property under the law is actually defined anything that's not real property or a fixture. So everything else would constitute personal property. And it could be tangible, meaning subject to physical possession, or intangible, which is not subject to physical possession, but you can, but it's subject to your legal ownership. So something like you own a copyright or a patent. And while I'm not going to, there is a chapter in the book, I think it's chapter 23, that's all about intellectual property. I didn't ask you to read that at the end of this discussion of personal property, and I'm going to talk a little bit about some of the intellectual property rights because we can kind of throw them out there, but just to give you an idea of what they are and what law governs them. So tangible property, intangible property is personal property, anything that's not real property. And then I have fixtures up here because I want to talk about them. Because like I said in the last definition, fixtures become permanent to real property and then they're considered real property. But before fixtures are actually attached to the property permanently, they are actually goods, i.e. they were once personal property. Then they become affixed to real property and then relatively permanent and considered real property. So we talked about that when we did mortgages, where you buy a furnace, it's a good, it's personal property, but once you attach it to your house and it becomes reasonably permanent, then now it's going to be considered real property. Acquiring ownership of property, how do we do it? there's a number of ways, right? What's the most common way? You buy it, right? Purchase the property. You can also acquire ownership of property by inheritance or through somebody's will. But there are a lot of other ways. It can be done by gift. You can find it. There's something called accession that we'll talk about. There's something called confusion. And there's something that we'll refer to as possession. So let's kind of go through them. I'm going to kind of work out of order than the list I gave them to you. But I like to start. Oh, actually, there's my list. Purchase, inheritance, gift. You find it. Or abandoned property is another way we're going to refer to it. Accession, confusion, and possession. So possession. What is possession? It's something that's in your control, something you have control over. So I pose this question. Suppose you give a classmate your new iPhone to examine. Is it in your classmate's possession? You might think, yes, it is, but actually it's not, because possession, the legal definition, is you have control. Something you have control over. So does your friend the classmate have your right to give it to somebody else? Probably not without your permission. So what your friend has is called custody. They have custody, not possession. Also, when you have possession legally, you have the power to exclude others from using the object. So once you may allow your classmate to use your cell phone, you can take it away and show it to somebody else. Or if somebody says, hey, can I see your cell phone? You can say no. It's yours. You have control and you can exclude. If you give it to somebody else in this example to examine, they just have custody. What if a tornado dropped a boat in your front lawn? Do you possess it? What if you weren't home? Do you possess it? No. So the rule is when no one was I'm not going to go to that rule just yet. So how do you get ownership through possession? That's the question I want to pose first. So how does someone get ownership through possession then? If we're talking about possession means control and being able to exclude. So the rule is one obtains ownership through possession when no one was the owner at the time the current owner took the object into his or her possession. And this is a very limited class of cases when we're talking about wild animals and abandoned property, because otherwise somebody owns it before you. So let's break that down. Wild animals. We're talking about people who might be hunting or pursuing an animal. The first to get it keeps it, i.e. possesses it, meaning they assume control and they can exclude. Do we see any problems with that? What if the animal gets away? What if the animal is shot on public property where you're allowed to hunt, but then it runs off and dies on private property? Well, the rules related to that is the animal gets away from you and it's caught by another. The one that it got away from does not become the owner. Once it escapes, it's back into the wild and it's anyone's to catch. So you won't, unless you catch it and keep it, it's not yours. So if it gets away from you, then it's anyone's fair game and somebody else can claim it or get it. If the animal's found on another's property or you trespassed on somebody else's property, the ownership is going to vest in the landowner. So if you shot a deer on public land and it runs off and dies on a neighboring property, which happens to be private property, it's no longer your deer. So the other class of cases is abandoned property, which raises lots of issues. And the definition of abandoned goods or abandoned property is property that has been discarded by the owner, and the owner has no intention of recovering it. So the clear, important words here are it's discarded by that owner, and they have no intention of recovering it. When that happens and you claim it or find it, you have title against everybody. Whole world, it's now yours, okay? You don't have to find the owner. It's abandoned. It's gone. What if you find that abandoned property on someone else's property? It's not yours. It belongs to the one who owns the property. If you find it in public place, and it's deemed abandoned, and whether, that's the other question, whether it's abandoned or not. It might be lost, it might be mislaid, so that's another question we're going to get to. But let's say somebody is cleaning out their garage and they put a whole bunch of stuff, rather than have a garage sale or donate it, they put a bunch of whole stuff right out at the curb on their trash night. I think that's pretty obvious of their intent, that they don't want it and they're discarding it. Can you go and pick it up out of the trash? You sure can. Be abandoned. So if you find abandoned property on another person's property, it belongs to that other person, not you. And now we're going to switch gears and talk about what if the property was lost or mislaid, and how do we determine that, and what do I have to do if I find something like that. So what's the difference between lost and mislaid property or misplaced property? Well, misplaced and mislaid property is property that the owner has voluntarily parted with and then intending to recover, but they forget. And then they cannot find or recover it. So it's kind of inadvertently forgotten. Versus lost, which is inadvertently and unknowingly lets it out of its possession, his or her possession. So it's slightly different. You have the property, you set it down, that's you buy it voluntarily, part with it, but then you either cannot find it when you're looking for it, or you forgot where it was. And lost is you just inadvertently and unknowingly let it out of your possession. So then what's the difference with abandoned property, right? Are these items abandoned? Finders, keepers, losers, weepers? Isn't that how the saying goes? But that's not how it works. It actually does not work that way. You have to have intentional discarding of the item for it to be abandoned. And in these two instances, it's not. So what are whose rights and all of that? So with mislaid property, it's likely that the true owner will return for the property. So if you are a finder of mislaid property, you don't obtain title. Actually, you have an obligation to return the property to the true owner. So for example, Michelle goes to a theater while paying for popcorn at the concession stand. She sets her smartphone on the counter and then leaves it there, where an employee finds it. Is this property lost, abandoned, or mislaid? It will be mislaid. Does the employee get to keep the smartphone? No. Actually, it would be the theater, technically, because if it's abandoned, it would be the theater, not the employee, because it's the owner of the property that gets to keep it if it's abandoned property. But it's mislaid property, so nobody gets to keep it. And actually, there is a duty. The theater owner has a duty of taking care of that cell phone while making reasonable means of learning who the owner is. So there is somewhat of a duty. What if you find a wallet in the middle of Margaret Street? You don't have to pick it up, but if you do, now the question is it lost, abandoned, or mislaid? Could be lost or mislaid, but you have a duty to take steps to return it. So you open up the wallet and you see whose ID is there, or you bring it to the police department, but you have a duty to return it. Now with regards to lost property, I have it on here. Well, we'll leave this up for a moment, but with regards to the lost property, if it's left involuntarily and then forgotten, the finder can claim the title to it against the whole world except the true owner. So if it's lost, you don't know how to find the person, it's yours, but if the true owner finds out you have it, you have to return it. If the owner of lost or mislaid property demands that it be returned, you have to return it, but if you don't, what could happen? Well, let me tell you before we answer that question, let me tell you about the rule here in New York State. This is a state rule with regards to abandoned property or mislaid property or lost property, and it's usually set forth in the statute. In New York, they do not distinguish between lost and mislaid. It's the same concept. And if an owner cannot be found after a reasonable time, then the finder gets to keep it. You take possession of it. In New York State, they have a 6-month rule. 6 months. Some states require that you make a diligent search to locate a true owner, but if you find property that is not yours and it's something significant, maybe you find an iPod on the ground or a cell phone, then you have to take steps to find out who the owner is, whether that's bringing it to the police department or seeing if you could put an ad in the newspaper to find the owner. Anyway, you have to take steps. In New York State, if the true owner doesn't come forth, you are allowed to keep it. What happens? So what happens if you don't return it on the true owner's demand? What can happen? Well, you could be sued for it. It's a tort, and the legal term is called conversion, but you can be sued for that. So for abandonment to kick in, what's the key? The owner must intentionally abandon it. So let's talk about gifts. What are gifts? Gifts are a voluntary transfer of personal ownership made without consideration. Remember consideration? That's that value for exchange, something that creates a contract. We don't need that here when we're giving a gift. But the one thing we do need, it must be given in the present. So if you make a promise to make a gift tomorrow or next year, it's not a gift. You need 3 things. You need donative intent on the part of the donor. That's the one giving the gift. You need delivery of the item. And you have to have acceptance by the donee, and that's the one receiving the gift. So we have our donor, the one giving the gift, the donee, the one receiving it. And you need all 3 of those things for a gift to have been made. So let's talk about intent. Well, you're going to look at the circumstances, and you're going to look at the language that the donor is saying. The intent is to give the property at the present time. Intent, the conscious desire. Here is my cell phone. You can have it. Is that a gift? Do I have intent? That's the first thing you got to ask. Do I have intent? Yeah, based on the language, it sounds like that I am giving up my cell phone to you. And then we have delivery. And what we're doing is we're exercising or giving up control of and ownership rights to the property. So remember, when we have possession, we have the right to control and exclude people, but we also have all those rights to use, possess, dispose of, and exclude others. So when you do this, you're giving those up. You're giving up control and you're giving up ownership. And that works well with tangible property. But what if we're dealing with intangible property or property that is not in the donor's possession? How do we actually effectuate delivery? If I have my smartphone, like I said, I'm going to give you my cell phone. I don't need it anymore, and I hand it to you. We obviously have conscious desire, based on my language and circumstances, to give it to you, and I'm doing that by handing it to you, right? I have a tangible good, I just give it to you, that's delivery. But in some circumstances, we might not have that ability. So Gina wants to make a gift to Harold of gold coins that she has stored in a safe deposit box. Of course, she cannot deliver the box itself. So how did she do this? Maybe she doesn't even want to take the coins out of the box. Maybe they're worth of such value and she doesn't want to take them out of the bank. So how do we do this? Well, she can give him the key to the safety deposit box and authorize his access. And have we effectuated delivery? We did. It's called constructive delivery. What if I wanted to give you my car that's parked in the parking lot? We're in my office at the college. And I said, you know what? I'm going to give you my car. Here are the keys. Is that effective delivery? Sure, by giving you the keys. I can't go out and pick up the car and hand it to you. But that will give the signal that there is constructive delivery. So it's an act that's equivalent to the physical delivery of property that cannot be physically delivered because of a difficulty or impossibility. You can also have a third party do the delivery as well, somebody who acts as your agent. And then we have acceptance. And there's not a lot of problems that are raised with acceptance. Everyone's willing to take a gift. This is usually presumed. I hand you the smartphone, you go, thank you. Or, that's great. The acknowledgement of taking it from me is going to be good enough. So we have two types of gifts, inter vivos, and it's pronounced causa mortis. And sometimes it's mortis causis. It's written one way or the other, but in its form of, I think the book has it this way, in the other form, mortis causa, it means in contemplation of death. Inter vivos means between the living. That's what that term means. Let's distinguish these two. So, gifts made during one's lifetime, inter vivos. Gifts made in contemplation of imminent death from a specific cause, i.e. not via will. Somebody's like on their deathbed giving a gift. That is the mortis causis, causa. See, that's a tough one to say. And the distinction between the two is their revocability. Once you make an inter vivos gift, there are no takebacks. It's irrevocable. Once it's complete, once you have the intent, donative intent, the delivery, and the acceptance, it's done. No takebacks. With the other, that I'm not going to try and pronounce again, with the other, it's a gift that is revocable. And it's revocable up until the time that the donor dies from the contemplated cause. And it's automatically revoked if the donor recovers. Or if the donee, the one who's supposed to get the gift, dies before the donor. Okay? So let's talk about a couple examples here. So Daisy tells Elmore that she's going to give him an electric guitar on his next birthday. Is that a gift? No, this is a promise to make a gift. Remember, you have to do it in the present. If she hands him an electric guitar today, then we'll have a gift. But this is a promise to make a gift, and it's not a gift. When Alice graduated from college, Alice gave her compact refrigerator to her, should say her, not he, her college roommate, Grace. Alice did not expect to need it again. However, 1 month after making the gift, Alice was accepted into grad school and once again has to prepare for dorm life. Alice telephoned Grace and explained what had happened. Alice told Grace that she wanted Grace to return the refrigerator to her. Does Grace have to return the refrigerator to her? No. What type of gift do we have? We have inter vivos, between the living, and it is irrevocable once it's done. We had donative intent. She gave her the refrigerator and didn't expect to need it again. She delivered it, and Grace accepted it. So in this instance, Grace does not have to return it. We have an inter vivos gift. Accession, that's our next way of getting ownership of property. And what this is it's an addition that increases the value of property that you already have. So if you have a ring and then you add a diamond to it, it obviously increases the value of that property. You still get to keep that property. Martin buys all the materials necessary to customize his Corvette. He hires Zach, a customizing specialist, to come to his house to perform the work. Martin pays Zach for the value of the labor. Does Martin retain title to the property? Yes, he does. Zach doesn't get any sort of property rights to it. And this is what we call accession. But what if we have accession that occurs without the owner's permission? So Patti steals a car and puts new expensive tires on it. Ivan, who's the rightful owner, later recovers the car. And the question is, does he have to give back the tires or compensate Patti for them? And the answer is no. It's bad faith. So the owner gets to keep the improvement and does not have to compensate the wrongdoer in this case. But what if it's an honest mistake? What if, it's done in good faith? What happens in that instance is the owner will retain property, but may have to compensate for improvement depending on what it is. Now, in this example, like I said, I just want to reaffirm the general rule is if it's done in good faith, the owner will technically retain the property, but will have to compensate for the improvement. What I'm going to show you now is a slight exception. A person takes a bushel of his neighbor's cotton, believing in good faith that he can. Let's say the neighbor grows cotton. It was just laying around. And then he makes a pair of socks. Who gets the socks? In this instance, the creator will get to keep the socks, even though it started out as cotton, and technically the neighbor owner owns the cotton. The creator made it something greater, something better. May have to compensate for the cotton, but the socks would remain in the hands of the creator, and that's a form of accession. Then we have confusion. This is when we mix up goods belonging to two or more owners so that the independent goods cannot be identified anymore. The main example of this is when we're dealing with fungible goods, grain, oil, fuel, things that are mixed together. Remember our grain in our big silo? If the mixing happens by agreement or mistake or some third party, everybody becomes tenants in common. You start mixing my grain with your grain and two other people's grain, and now we don't know whose grain is whose. We're all going to take ownership as tenants in common. Remember our definition for that. We're going to own our a fraction of interest, and we're also going to pass that interest to our heirs if we die, or that would be the interest that we would get to transfer if we wanted to sell it. So we have 5 farmers. They enter into a cooperative agreement. Farmers do that to kind of divide pricing and keep pricing low so they're not competing with each other, so they enter into a cooperative agreement. So each fall, the farmers harvest the same amount of number 2 grade yellow corn, and they store it in silos that are held by the cooperative. So all of these, so what are the farmers' ownership rights? They each have 1/5 of the corn. Each farmer owns 1/5 of the total corn in the silos. They can't say, oh, this one came from my farm and this one came from my farm. They can't. It's all together, and you can't determine. It's mixed. So if something happens to one of the silos, one of the silo burns, each farmer will bear 1/5 of the loss. So that's our discussion on personal property. We're going to talk about bailments, and then I want to talk a little bit about intellectual property on different slides.